Muted.
Hello and good morning, and welcome to today's webinar, HR Spotlight, What's Changing in 2018. This webinar series is a new initiative that we are providing free of charge for our clients. Our goals are to provide educational material on HR-related topics, to help you avoid HR pitfalls, to explain ESI's processes so you can streamline your daily tasks, and to answer your questions. My name is Miranda Wooten, and I will be your moderator today. I'm an HR business partner here at ESI. Today's presentation is scheduled for approximately 45 minutes, with additional time at the end for questions and answers. We will be recording this session so that we can publish it to our YouTube channel for future access, and afterwards, we will provide a copy of the PowerPoint presentation for your reference. Cheryl Denning will be the presenter today. She's an HR business partner here at ESI, and she's been with us for 2.5 years. Everyone will be muted during the presentation. However, feel free to submit questions via the chat box and GoToMeeting, and we will address these questions at the end of the presentation. At this time, I will turn things over to Cheryl.
Thank you, Miranda, and thank you again, everyone, for attending today. So, what's changing in 2018? Today, we're going to talk about some of the current issues you may be facing in your workplace, and we're really going to gear this talk towards business owners, maybe your HR staff, and even your managers. So, one thing before we jump into all the new and maybe not new topics today is some of these items, okay, most of them, are very controversial. Some are even politically charged. These are social issues, maybe religious issues that are real important in your workplace, and that's why we're going to talk about them. But today what we're going to talk about is just sharing information. We're going to do that to help keep you out of the courtroom, keep you from having to open your wallet for pricey settlements. That's our goal today. So aside from our personal views, we're going to kind of, in the spirit of that, keep everything focused on how it plays out in your workplace. So help, I know this could be controversial, and still hope that it's going to be very helpful for you. All right, our first topic is immigration enforcement. And the reason that the current administration had promised, even last, to increase immigration enforcement 4 to 5 times in 2018. And guess what? It's here. We're already seeing it. There's been an increase in worksite inspections just in the last 2 months. So who enforces this? The U.S. Immigration and Customs Enforcement, they call it ICE, is the agency that enforces immigration laws and I-9 compliance. And what they said is they will prosecute employers who knowingly hire unauthorized workers. Now, their focus, they have said, is going to be on illegal immigrants who are involved with gangs, maybe some other criminal activity. But of course, in the course of those investigations, they will also deport individuals with no criminal ties if the person is in the United States illegally. Now, while you may feel comfortable that this doesn't affect your workforce, your company, just know that those investigations are increasing. In fact, one of our ESI clients is already in the process of an I-9 audit. They were served back in January. And when that happens, what we at ESI do, besides helping maybe lead that audit for you, assisting you in responding to that, is we gather information. So one of the things that the investigator said was they are focusing on the oil and gas industry because they're trying to determine or prevent anybody with terrorist activities from sneaking onto an oil rig, being in these type of environments that could have a large impact if they have terrorist intentions. So that's something now that we know we can share with you. But again, this is going to cross all industries, so the bottom line is we all need to be diligent when we're filling out our I-9s, when we're reviewing documents, in order for us to be in compliance with these laws. So let's quickly review, since we know this is kind of on everybody's radar, let's quickly review the I-9 regs since, again, audits are going on right now. The first thing we want to point out is that employees must complete Section 1 of the I-9 form no later than the first business day of their employment. Then on the other side, the employers must complete their sections no later than the third business day of employment. And this is important because a lot of us, I know we focus on, we've got 3 days, we've got to fill out the I-9 by the third day. And sometimes we forget that the employee has to do their section on the first day. So we wanted to point that out, give you that friendly reminder. Another topic that we just like to point out, again, I wouldn't necessarily share this information with every employee, and you don't have to do that. But the Social Security number is voluntary on the I-9 form. And the reason for that is because some people like to keep their Social Security number very close to them and not have it out on a lot of different forms, a lot of different outside entities. So for purposes of the I-9, if the employee asks you, do I have to give my Social Security number on this form, you can tell them no, they would just put NA in that box. All right. And another thing that was added last year is the checkbox for if an employee used a preparer or translator. That's right under the employee's signature on page 1 of the I-9. So we kind of wanted to point that out again, make sure you remember that was kind of new last year, and sometimes we see it gets missed. So make sure the employee fills out that box and checks which box is appropriate. So reviewing documents. You must make, as an employer, a reasonable effort to review the documents that are provided with the I-9. However, you are not the document police, and this comes straight from the I-9 agency, from the USCIS. You do not have to drill down, determine complete authority of every document. You just have to do a reasonable effort to ensure they're genuine, which means make sure that, for example, if you get an out-of-state driver's license, go online, go to the transportation department of that state, and there'll be a sample of that driver's license there, and you can look and see, okay, does this look reasonable? Do I see anything that stands out that's different or that this may be forged? So that's a good, reasonable effort. But also make sure that the person presenting the ID is the person in the pictures on the ID, because that would be a very embarrassing finding if you were audited. So just take a quick look. I know we get moving quickly sometimes, but go ahead and look at the picture on the document, look at the person providing, and just make sure there's a reasonable correlation. So that's what you have to do, and that's an employer's responsibility when reviewing documents. Another aspect of the I-9 regulations is non-discrimination. So what this means is that you cannot tell employees which IDs they must use. You can't deny certain types of work authorizations. As long as the document is valid, then you need to be able to take that document. And by valid, we mean that it hasn't expired. So definitely be checking those expiration dates. So when employees are completing the I-9 form, what you must do as an employer is make this list available to them that you can see on your screen. It's called the list of acceptable documents. And the reason we say that is, as an employer, you can't tell employees what documents to bring. And I know we get it, it goes kind of quick. We're like, okay, make sure you bring your driver's license and Social Security card. Well, you just told them which documents they have to bring, when they really can bring any of these documents. So just a little hint to you, if you're being audited, your process is that you make this list available to all employees and let them choose which document to bring. So along those lines, just a reminder, the employee can bring one document from List A or two documents, one from List B and one from List C. Special notes for Social Security cards. A signature is not required in order for a Social Security card to be valid. So again, we're not discriminating, we're not making it difficult for the employee, so If there's not a signature on there, you can still accept that Social Security card. Now, when you cannot accept a Social Security card is when it has this message or a similar message on it. You can see on your screen, valid for work only with DHS authorization. What that in effect does is make this Social Security card invalid as a List C document. So what you would do in that case is tell the employee, we can't accept this document for List C. Is there another document you can provide? And then they'll do that. And sometimes what will happen is, let's say then they bring another document. Let's just say maybe their permanent resident card. So you're filling out the form, and you're going to now fill out, because the permanent resident card is a List A document, you're going to put the information under List A. Well, sometimes we'll see both. You're already listed something under List B or C and List A. So that would be a finding on an audit too. So just remember, as you're going through this, or if you have this situation come up, only document the identification under the list that is appropriate for that. Okay, another important point about I-9s is if you receive an uncommon document, don't refuse it or ask for another document. And there are a lot of documents down there that a lot of times we don't see. So your first resource, if that happens for you, is the I-9 Handbook for Employers. You can find it online under I-9. It's probably about 80 pages, but everything is covered in there. Documents you can accept and documents you can't. So let's say you get a foreign passport or a visa, or one time I got a Native American tribal card. Go ahead and go online and look and see. You can type that verbiage in, and it'll take you right to the section that addresses how you would handle that type of document. And then always, ESI can assist you if you get something that you're not sure of and you just want us to help look at it also, give you some guidance. Please call us. That's what we're here for. But definitely don't refuse it just because maybe it's something we don't see very often. All right, to recap, I-9 audits and workplace immigration investigations are increasing. Again, it's going to be up to 5 times more than in the past. So prepare yourself. What you can do as in your own company is do your own internal audit of your I-9 forms. Look at them and see what things are missing, what may be incorrect. And if you find an issue, then correct it. It's always going to be better than waiting until the investigator finds it for you. So what you would do, let's just do a quick example. If you did find something that was incorrect on a document, the first thing is you never want to destroy the original document just to replace it with the new one. So if you do have to do a complete new form, you're always going to keep that original and attach it to the back of whatever correction you make. In most cases, you can simply just make a correction on the section. Let's say you did put that Social Security card and the permanent resident. What you would do is just draw a nice line, one line, they say no whiteout, through the incorrect information, add the correct information, and then initial the change. The other thing you have to do in that case is attach a memo to the I-9 explaining the correction and any steps you've taken to prevent it in the future. And there's samples in that handbook, and ESI can help you with that if that happens. So again, don't feel like you have to wait till the auditor comes knocking on your door. Go ahead and take those steps now and let us know if we can help you with it. All right. Another topic that's been very high profile over the last few months is sexual harassment. A lot of cases have surfaced recently, especially in the entertainment industry, and there's been some significant fallout. I'm sure most of you have seen this on your morning news. So what's prompted also this #MeToo movement, which basically the victims of sexual harassment or abuse have banded together to raise awareness. So what this means for you is really no laws have changed, no workplace laws have changed at this time. So there's really no handbook changes, anything that you need to do to really make a change as far as compliance is concerned. But definitely what we're expecting is maybe employees who have experienced this, whether it's at your office or somewhere else, are going to feel empowered now maybe to bring this forward. So as an employer, we want you to be prepared to handle that if an employee comes and says, you know, maybe it's a one-time incident that happened, or maybe they'll even come to you with something that's been happening for years. So as an employer and as somebody who cares about their employees and would never want this to happen or allow it in their office, what can you do? So the first thing, adopt a strong anti-harassment policy. And as a partner with ESI, you already have that. That's part of ESI's handbook. The anti-harassment policy has very common language that complies with all the laws. It addresses the definition of what harassment would be considered, what managers should do when they hear about it, and it has a complaint procedure also for employees on what they need to do if they feel like they've experienced this in their workplace. So you've already got that. What I would encourage you to do is look at that, become familiar with it, understand that for your own company. So train yourself first, then we're going to train your employees. And what that means for harassment is training your employees separately and then training your managers at another session. And obviously the reason for that is there are some things you need to talk about your managers with as far as identifying sexual harassment, how to handle a complaint, and what they need to do if this happens in their department to make sure they're not retaliating against the employee, treating them any differently. So there's a lot of conversations and training that needs to go on with your managers separate from employees. Best practice for this is to train everybody once a year. When you are able to show that, then if you ever do have a claim, you're showing that as a company you did your due diligence to try to prevent this kind of thing. And then finally, enforce your policy. So now you've done your training every year, you've got a good policy, you know about your policy. Let's say you get a complaint. And you're going to hear me say this a couple times. Don't sweep it under the rug. And so treat every complaint as serious. We're going to talk a little bit about investigation. But as you know, and I think you probably heard, some of the fallout that's been happening in the entertainment industry is because other people knew that this was going on and didn't do anything. So we don't want that to be us. So make sure you're following up on complaints and investigating all complaints thoroughly. And when I talk about investigation, I know this is where, this is kind of fearful for a lot of us. And a lot of us get afraid, okay, am I going to say the wrong thing? Should I investigate this? You know, I can't believe it happened with this person. They're a really good employee. I can't believe this is happening. And we're not really sure what to do. So when you get a complaint and you're going to start an investigation, the first thing you want to do is make sure it's a neutral third party. ESI can do those for you. So that kind of separates it, and we're a neutral party for you. If not, make sure it's somebody who in your company isn't maybe in the same department, those kind of things. So watch for that. Make sure it's a separate party. And then what you want to do is separate the people that are involved. And when I say that, I have to say it cautiously because we're going to talk about retaliation in a minute. So when you separate the people who are involved, you want to make sure it's not retaliatory. So you don't want the accuser to necessarily be now transferred to another department all of a sudden while you're still in your investigation mode, okay? So think about that, and again, ESI can help you through those kind of situations, but definitely don't make that person now who has made an accusation stay in the same situation until you figured out what's going on. Sometimes we have to put, depending on the severity, someone on a short administrative leave, but again, let us work with you on those. So you've taken the complaint, you've started the investigation, and when you investigate, what you're going to do is talk to the accuser and take down the facts. You're going to talk to the accused person and take down their side of the story, their facts, and you're also going to talk to any witnesses. And so once that's done, you're going to gather all the facts, review them, and come up with your findings, whether the accusation was substantiated or not, or maybe partially in some ways. And after you've determined your findings, again, this is going to be confidential. It's only going to be shared with only people who need to know, which is probably going to be your company owner, maybe an HR person in your company, and the third party. You need to be careful about how many managers are made aware and work through that based on a situation. So once you determine the finding, you're going to determine what action you're going to take. And this, I think, is a scary part for people. We think everything's going to end up in a termination. Not always. Sometimes maybe some additional training is needed. Sometimes just some awareness for your entire company. But as long as we're not making that determination before we investigate, then we're doing our due diligence to get all the facts and make a proper finding and take proper action based on that. So again, just to wrap up, don't be afraid of this. I know it is scary. Let us work with you or another third party and make sure you're developing a culture in your office of non-harassment. Everybody needs to know from the top that that's how you feel as well, and that's what the expectation is of everybody. And once you start doing that, any complaints, any situations that do come up are going to be, you're going to be able to handle appropriately. Okay, another form of harassment is gender identity and sexual orientation. So to cover this topic, I'm going to give you a quick history lesson. So Title VII of the Civil Rights Act, in the HR world, we just call it Title VII, so you'll hear that. That law makes it illegal to discriminate based on race, color, religion, sex, and national origin. There's a couple other subsequent laws that prohibit discrimination on age, disability, and pregnancy, just for your knowledge. But sexual orientation, you didn't hear me say that in any of those laws, right? So it's not covered specifically under Title VII. However, case law, the Equal Employment Opportunity Commission, the EEOC, have said that sex discrimination, as covered under Title VII, also includes discrimination based on gender identity or sexual orientation. And always remember this applies to applicants as well as employees. So prior to the current administration, employers basically were working under that assumption that these topics were covered under discrimination laws. They built policies, maybe their own culture was such that, you know, they were investigating these type of claims and also taking action based on that because it is a covered protected class. Now, fast forward to October 2017. So basically what's happened this past year is the U.S. Attorney General, Jeff Sessions, he issued a memo back in October that instructing the Justice Department that federal law does not protect transgender individuals from workplace discrimination based on sex. So basically he's just saying this law does not clearly say this, so therefore we aren't going to provide protections to transgender individuals. So what does this mean for you? So basically, for employers who already are following those types of laws, who are providing protections for transgender based on sexual orientation, based on gender identity, if you're already doing that, then you really don't need to change anything right now. We're kind of in a wait and see mode. The Supreme Court, we're expecting, is still going to weigh in on this because those claims are still going to be submitted to the EEOC, and those are still going to be run through the courts. So even though the Justice Department is kind of standing to the sideline, cases are still going to go through, and the Supreme Court will be probably, we're expecting, issuing determinations later on. So I wouldn't make any changes right now. If maybe you haven't really had this come up in your company before, if it does, the bottom line that we would recommend for you is if an employee presents themselves as a male, identifies as a male, then they use the men's restroom. An employee who identifies and presents as a female, they use the women's restroom. Now, we understand this is a controversial topic. We understand that other employees who aren't directly affected by this law may have a problem with these types of situations. So work with an HR professional when this happens, because what you don't want to do is, and again, we're here to keep you out of court and keep you from any settlements. So what you want to do is find a balance and work with an HR professional or legal counsel if these situations come up in your company. So about equal pay. Gender pay disparities have received quite a bit of increased publicity over the last couple of years. Even last year in March, there was a Day Without a Woman where women took off work, marched, protested to raise awareness for this topic. So that's been going on for about a couple of years. Well, what happened this past January is, oh, and I'll tell you, the folks in the picture, this is Michelle Williams and Mark Wahlberg. They're movie stars. And so this past January, they were in a movie called All the Money in the World. And Kevin Spacey was also in that movie. And Kevin Spacey is no longer in that movie because of sexual harassment. As you saw in the previous slides, he was removed. And I think some of us are aware of that situation. So what they had to do was then refilm all of the scenes that he was in because they're using a new actor. When that happened, Michelle Williams was paid $1,000 for her reshoot, and Mark Wahlberg was paid $1.5 million. So all of a sudden, they became the poster children for pay disparities. And there's a lot to this, and this is going to happen even in your workplace. So Michelle was the star of the show, and Mark has kind of a lesser role. However, they both had about the same number of scenes. And what happened is Michelle Williams told the filming company, her agency, that she was going to do this for $1,000 because they needed to get the movie out. Everybody's got a lot invested. This is something we didn't expect. Let's just get it done. We still want the movie to come out. And Mark Wahlberg said $1.5 million, and he got it. So, and in the end, he did donate that full $1.5 million to a legal fund for sexual harassment cases. So yes, there's some other things going on with this, but again, what we expect is this type of publicity, this type of awareness could bring this up in your workplace. So it's important for you to know what's going on in your company, to know, which I'm sure you do, to know how this law would affect you if somebody came to you and said, I think I'm being paid less, and I think it's because of my gender. So what the law requires is equal work for jobs on the performance of which requires equal skill, effort, and responsibility, and also similar working conditions. What would happen if there was a finding against your company is penalties with back pay up to 2 years, 3 years if your violation is willful, and liquidated damages, which is like pain and suffering, equal to the back pay. So these can get pricey pretty quickly. So can your company survive an equal pay claim? Do you have possibly a single situation that could invite a lawsuit, or even a systemic violation that pervades your entire company? And a lot of times what happens is this could be intentional, and we'll just be honest, there could be people doing this intentionally, or maybe inadvertent. So what you want to do is look at where your employees are being paid, what levels they're being paid, in association with their position, their gender, their race, those kind of things. So when you're looking at that, some areas where you can see pay inequalities are in starting pay, in promotions, in raises, but even in something like maybe a bonus or commission structure, if the men have one structure and women have another, or maybe even opportunities for overtime or higher paying shifts. If those are going to one gender versus another, then you need to determine, okay, is this just inadvertently happening and I need to find a way to correct it, or is somebody in my company purposefully paying men more than women? So what you would need to defend a claim of unequal pay is be able to show that you've either got a seniority system, a merit system. These are things that are valid reasons why you would have a difference in pay. Even paying differently because of the quantity or quality of work, that's still okay, and we get that. You just need to be able to show it. Show that any reason other than sex is why those pay differences are happening. So we talked about some of the outside efforts that we're now seeing because of the awareness that's being, the publicity that we're seeing lately. So some efforts are happening, activist efforts. Some folks are asking for a ban on asking applicants their salary history. And the reason for this is the, how'd you say, like, basically what they think this is applying to is, let me just give you an example. If a woman is making certain pay throughout her career and she has been paid less because of her gender, and then she comes to your company and you don't do that, you pay everybody equally, and you ask for her salary history, and then you make her pay decision based on what she's been making in the past. Well, you may have just inadvertently continued the discrimination against her pay, okay? So some folks think that this is a way to stop that from happening. Some folks don't think it is, or it does make it difficult for employers to determine how they're gonna pay, and we'll go into some ways that you can resolve that. Just wanted you to know that is a push that's out there and something for you to maybe think about. Pay transparency. There were some pay transparency rules that were rolled out for federal contractors. They have been rolled back. But it opens up the thought process of, if our employees know what everybody's being paid, if we've got pay scales, then talking about it becomes more comfortable and not a way that, oh, don't talk about your pay. And then what happens in the end is these type of disparities may become hidden and we don't know about it. So that's kind of the thought process behind that one. And then there are some states and international laws that are being pushed for to help equal out the pay gap. All right, so what can you as an employer do? Establish a pay grade, have a merit increase matrix. What qualities or what criteria are you using to give raises to bring people in? Reduce managerial discretion. This doesn't mean you have to micromanage or take those decisions away from your managers, but any type of oversight or centralizing your pay decisions can help prevent one manager, two managers from causing an inadvertent or intentional pay gap. And this is interesting. Home Depot had a case they lost a while back, about $86 million worth. They were growing really quickly. And as they were bringing people in and promoting people out in their stores, a lot of their managers were paying men more than women. And in the end, because there wasn't enough oversight, that cost them about $86 million. Okay, be sure you're documenting how you make your pay decisions. It's going to help if you have those pay grade charts, those raise matrix. But if you're a smaller company and you hire somebody, you decide what you're going to pay them, and you move on down the road, you don't have a process that you followed, any documentation of why you made that pay decision. Maybe it was their education, maybe it was their experience, they had more than someone else. But if you don't record that, the burden of proof would be on you, the employer, if a claim was made, and the employee could win just because you're not documenting why you made that and showing the reasonable reason why that happened. And then again, we're going to say this again, investigate complaints thoroughly and accurately. Don't sweep them under the rug. All right. Okay, retaliation. This is absolutely the highest number of employment claims that the EEOC has. And it's an interesting reason why. A lot of what happens, you may have a claim of discrimination or harassment or even disability discrimination. And as that claim is processed, it may come to find that it doesn't have any merit. There was no discrimination. But in the meantime, one of our managers may have terminated an employee, transferred them, harassed them throughout the time of this investigation. So now guess what? The retaliation claim does have merit. And that's what they're actually seeing. They said at least half, over half of the claims that are found to have no merit, but retaliation then happened. So you as an employer need to make sure that you create a culture, an expectation that retaliation doesn't happen in your company. So anytime that you get maybe a complaint about discrimination or harassment, maybe somebody reports a safety violation, these folks are going to be protected now legally against retaliation. Sometimes even if maybe an employee applies for FMLA, you know, they've got a sick parent they're trying to take care of, they meet all the qualifications, but now their manager is upset. It's made it hard for him to meet his goals or her goals, and now they're going to treat that employee differently. They're not going to consider them for a promotion. They're going to harass them throughout the day. They're not going to approve their vacation when they approve other people, okay? Those kind of things are considered retaliation and are protected under these laws. Also, what if somebody participates in an investigation? We talked about those earlier. Say somebody's a witness, and they open up, they participate fully, they tell the truth, and now someone else in the department is maybe in trouble or having some action taken against them because of the findings of that investigation. So you can't treat then the witness, the accuser, any differently or retaliate against them because they participated in that. So again, make sure that this is a topic that you, as a leader in your organization, are creating an environment where this is not acceptable. All right, something new that's also come up, we've seen a bit, is paid sick leave. This is an interesting topic because we really expected that any type of paid sick leave law would be repealed with this new administration, and we really haven't seen that yet. In fact, just this month, Austin City Council approved paid sick leave for their employees. Now, it doesn't go into effect till October 1st, and we are expecting that the state legislature will push to repeal that. But it's still out there, and what we're seeing with politicians is kind of a two-faced, two-approach effect of this. So on one hand, the administration is very employer-focused, so they don't want to impose any burdensome paid sick leave type of burdens on employers. However, it's not politically appropriate or help with their votes if they're telling employees, no, you can't have paid sick leave. So what we see is a lot of face time given to this, but in the end, we do think that some of these laws, and some have been passed, several states have already passed it, some of this will still be coming to fruition. It may just be a little slower. So for you as an employer, just keep an eye on that in your own locale, and we here at ESI are doing the same. Also, paid sick leave for federal contractors. Just wanted to throw this out. If this applies to you, this was put into effect last year. A lot of the federal contractor executive orders were repealed. This one was not. So that is in effect, and if you're covered under any of these types of contracts, Davis-Bacon, McNamara O'Hara, then you could be covered by this policy and you need to be following the guidelines. Okay, a few other things that we're going to watch for in 2018. Ban the box. This is asking employees or applicants about their criminal history before you make an offer to them. This came out last year, even the year before. This is still on our radar because we want to make sure that employers who are in areas where this is the law, that you have checked your applications. One of the things we're expecting is basically professional plaintiffs. So applicants who will go around and apply at different places until they find somebody in a covered area who still has the question about criminal history on their application, then as soon as they do that, guess what? They've got a claim. And they get a settlement, it may be small, and then they go to the next one. So we encourage you, look at your application, make sure if you're in one of these covered areas, and if so, this does not mean you have to hire somebody with a criminal history. It means you have to wait and do that after you've made the offer. The theory is give everybody a fair chance, make the offer. The offer is contingent on the background screening. So be aware of that, and if you're in one of those areas, work with your ESI people. Definitely check your application and make sure that that's not on there. Social media is still a hot topic. Clearly, a lot of awareness is being brought to topics because of social media, and how you handle social media situations in your workplace is important. There are some protections that you do have. Employees cannot go out and basically curse out a manager on social media and still and that be okay with you as an employer. However, there are some privacy, free speech type of protections that employees would have in those situations, so it's a delicate balance. So your ESI handbook does have a social media policy. If a situation comes up in your employment, talk with your HR professional as you're working through how you're going to handle that to make sure any of the protections that employees do have, that you're taking that into consideration. Again, doesn't mean you have to allow everything. You just need to be thinking about it. Workplace violence and weapons. Unfortunately, we've seen this in the news. We continue to see news stories where this is a situation. And so as an employer, you can have a weapons policy where you don't allow weapons from your customers or from your employees. So you can do that. There's guidelines you have to follow. Also be aware that if you're in an area that has open carry laws, there's some ways you have to handle that, but it is still something you can ban from your workplace. And then as far as violence is concerned, when these things happen, we know that it can even be scary for employees. They don't know if somebody may come into the workplace and commit violence, mass violence against your employees, against the workplace. So as these things happen, be aware of your employees. Think about how you can help them feel safe. If they specifically come and ask you, in fact, even in our Houston area, and I know this is in a lot of areas, we just put on a active shooter drill. And so there are law enforcement agencies who will come out and do an active shooter drill with you. So I know that's kind of intense, but just something for y'all to think about because we know this keeps coming up in the news, sadly. All right, cybersecurity. This was something that came out for federal contractors, but also we think is on the radar. For you as an employer, just make sure, obviously, your employees and your customers' online information has to be protected. So we haven't really seen any law that has stuck yet that you need to actually take action on, but we think it's something that's going to be coming down the way. So we're going to keep watching for this, and it's important for you as an employer to kind of know what cybersecurity you have in your company. And then I'm going to throw in the Affordable Care Act real quick because we talked about changes in 2018, and as much as we want things to change with that, actually, from an employer standpoint, what you have to do to comply with that act has not changed. So we will keep you posted. We are watching this carefully, but there are still reporting requirements. Some of y'all are even right now doing your 1095s and 1094s. If you have over 50 employees, this still applies to you. So we can't throw in the towel yet. And again, keep an eye on it. We'll keep an eye on it for you as well. Okay, so that concludes the meat of our webinar today. What we want to do is if you have any questions, we're going to look at those real quick. So go ahead and if you have something that came up, type it in the chat box. We'll answer those. We have a few more minutes to do that. And let's see. Okay, what if we find an employee who is working illegal but has been at our company for years? Okay, that's a great question. Again, we gave you some tools so that doesn't happen in the future, but if it does, there are a few situations where that employee may still be able to continue working while they're providing the proof of their document, something like that. But even those, most of the time, that employee is going to have to be off your work site. You cannot continue to have them employed. So if that happens, work with your HR professional, let us know, and we'll help guide you through that. But for all intents and purposes, that person cannot be employed by your company or on your work site, even while you're figuring out how to handle it. Okay, let's see. Can we hire an employee without a social security number? Okay, this one probably came up because I know we talked about the social security numbers on the I-9. Great question. While the I-9 form on its own does not require a social security number, to be an employee, you do have to have a Social Security number. So I think the theory behind that is just preventing them from having to put it on every form they fill out. But yes, they do still have to give you that in order to be employed. Okay, I don't see any other questions right now, but definitely feel free to email us. Oh, you know what? We do have a couple minutes. We got one more. If the documentations for the I-9 have expired, are you required to update the I-9? No. I say no. There are a couple of documents that do have an expiration date that you must get a recertification or a new document from that employee. It is very rare, very rare. So your driver's license, your passport, those do not have to be re-given, or they don't have to provide them when they expire. And in fact, it's important that you don't ask for them to provide a new document when it's expired. Okay, what are the covered areas requiring criminal history? I'll tell you right now. Right now, I know that in Texas State does not, but the city of Austin does. So if you're in Austin, you cannot ask that question prior to the job offer. There are several other states. Yeah, a lot of other states have these laws. So let us know, email us what state you're in, and I'll just tell you, we don't all work with all the states, so we'll find out for you. Let's see. Okay, good questions. So let me, again, please email us if you have other questions. And before we leave you, I did want to let you know, ESI has partnered with Business Legal Review. And the reason we did this is because they provide a learning management system that can give training to you, to your employees, to your managers. And where we see a lot of benefit from this is definitely with your managers. And I say that because even the topics we've talked about today, you may have every intention to not discriminate, no harassment, and unfortunately, you may have a manager who does, maybe they just don't know. Maybe they're just not aware of the law. They really do want to help people, but they think they're doing that, but they're not following the law. So this is a great tool for employers who want to have a resource for their employees, for their managers, to get additional training. They can do it on their own time. It's online, self-paced, and what's even better is you can set up an administrator or as many administrators as you need to oversee it. You can assign trainings to people. You can see reports of your managers who are attending the trainings. So again, we thought this was a good partnership, and for that, we even priced it pretty reasonable. Sometimes trainings like this can cost anywhere from, I don't know, $300 up to like a couple thousand. I mean, sending somebody to training is expensive. This system provides up to 70 self-paced courses. A lot of times they're adding new ones all the time. So you would have access to all of those HR trainings for $10 per user per month. So like for $120 a year, you can have a system that's really high class, easy to use. And so we wanted to bring that to you. Again, just something that might help you. So wanted to give you awareness of that. All right. And if you have more questions on that, please let us know. We did get one other question, and since we have time, we'll go ahead and add that. So let's see. How would you handle a situation when you suspect a Social Security card is not valid? So my first question, if you had called me about that, is why do you suspect it's not valid? Because Social Security cards, you can see, basically, you can see what a Social Security card should look like. If it looks different than that, there are some that are pretty old, right? So you can go online and you can see different versions of Social Security cards, okay? So you would look at that and go, oh, okay, it's just an older one. So that might be one way that you can check. Otherwise, let's say, again, I'm just going to make this up because we don't really have the actual situation. Let's say some of the numbers look maybe like they're erased or redone, something like that. Definitely, I would say in that situation, work with an HR professional because, again, before you say, no, this doesn't look right, go ahead and bring me something else, you want to make sure you maybe get another set of eyes on it and get some professional advice on it. So that's what I would say in that situation. Okay, let's see. I did get another one. We're an open carry state and have several employees who have concealed carry license. What types of policies can we institute to protect ourselves? Okay, in general, I'll respond to this. It may differ by your state, but most states who have open carry laws, you can still, as an employer, ban weapons from your facility. When you do that, the employee then can still keep that, they have to abide by that. They can keep the weapon in their car, in their locked trunk. So again, we'll look at each state when that comes up, but for the most part, that's what we see across different state laws. And and when you do that, remember, because it involves your customers, for the public, you do have to put a sign on your door that you've banned that from your facility. So those are some other caveats to think about when you're working with your weapons policy. Okay, another one, should you do a new W-4 each year? You don't have to do a new W-4 each year. So no, existing employees, no, you can continue to use their W-4 year to year. Now your employees, they can make an update to their W-4 at any time during the year. But yeah, requiring it, no, you're good. Okay. Let me just check, see if we got anybody else. Thank y'all for submitting these. These are great questions. Okay. Okay. Well, again, we thank you for your time. We really had a great time sharing this with you, and we hope it was helpful. And if it just made you think of something else, that you definitely call us. That's why we partner with you, and you partner with us. So let us know. Feel free to email us anytime. Oh, and let me just say, has a 2018 W-4 been published? No. As far as we know, they haven't. I personally checked a couple weeks ago, but our payroll department has kept up with that. And right now, they're still using the 2017, and we're waiting for the 2018. Okay, everyone, y'all have a great day. Email us if you have anything else, and thank you again for attending.